Good morning. I hereby call to order this 12th meeting of the Pennsylvania Public Utility Commission for the year 2018 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And as a reminder, just want to remind people that our emergency procedures are noted on the inside cover of our agenda. The first matter for today's agenda is the approval of the minutes for the meeting July 12, 2018. And I turn to Vice Chairman Place, who is the editor.
Thank you. I have reviewed the minutes of the July 12, 2018 public meeting and move that they be approved as submitted.
You have heard the motion of Vice Chairman Place to approve the minutes of July 12, 2018. Is there a second?
Second.
Second by Commissioner Kennard. Any further discussion or edits on the minutes? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. And now I will call up our Secretary, Rosemary Chiavetta, who is going to lead us through today's meeting agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Morning.
Secretary.
Your various bureaus and offices have prepared the following agenda items for your consideration. Let us begin on page 1. It is recommended by Director Bechtel and the staff of the Bureau of Consumer Services that the Commission adopt the proposed tentative order regarding the Universal Service and Energy Conservation Plan for the UGI utilities.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2 and matters presented by Acting Director Marinko and the staff of the Office of Special Assistance, it is recommended in an omnibus motion that the Commission adopt both items on page 2 and the first item on page 3, noting that the second item on page 3, Marlene Broman versus West Penn Power, has been postponed until the public meeting of September 20th. Continuing on page 4 with the omnibus motion that the Commission also adopt all of the items on page 4, ending with the complaint of Daria Kovikova versus PA American Water Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing at the top of page 5, it is recommended that the Commission adopt the proposed opinion and order in the complaint of Stephanie Maxwell versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion?
Yes, I have a statement on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I'd read it in its entirety. There have been several cases that have come before the Commission recently requesting commission-based payment arrangements. In these cases, household income is calculated to determine the length of the payment arrangement. Though I agree with the staff recommendation in this particular case, I will note, as I did in the recent case of Ms. Cozart versus PGW, that Chapter 66 defines household income as the combined gross income of all adults in a residential household who benefit from the public utility service. Additionally, there is recent case law, including an earlier 2017 case, which specifically affirmed that SSI payments to minors are not to be considered part of the complainant's household income, and as such should not be included in income when determining the payment arrangement terms. Though the outcome of this case does not result in a payment arrangement for Ms. Maxwell, it should be noted that for the purposes of calculating the terms of commission-based payment arrangements, minor income is not to be included. Thank you.
Thank you, Vice Chairman Place. Any further comments or discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 5, it is recommended in an omnibus motion that the commission adopt the 2 remaining items on page 5.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 6, it is recommended that the commission adopt the proposed opinion and order in the complaint of Catherine Hack versus the Pennsylvania American Water Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? I do have some comments. I ask that my comments be placed on the record in its entirety. On August 8th, 2018, Ms. Hack filed a complaint alleging that Pennsylvania American Water Company was threatening to shut off or had already shut off her service and that there were incorrect charges on her bill. Pennsylvania American Water Company's answer denied the allegations. The scheduled hearing convened on February 22nd, 2018, but the complainant failed to appear. The March 6, 2018 initial decision dismissed the complaint without prejudice. The complainant filed exceptions on April 13, 2018. When a party fails to attend a scheduled hearing, such failure to appear will be deemed a waiver of the party's opportunity to participate in a hearing unless the presiding officer determines that the failure to be presented was unavoidable. Because this is a pro se complainant and because I see no attempted abuse of our administrative process, the dismissal should be without prejudice. I support the initial decision of the administrative law judge, and I will be voting no on the staff recommendation. Any further comments or discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? I will be voting no. So the motion passes 4-1, noting my dissent.
Continuing on page 6, it is recommended in an omnibus motion that the commission adopt both of the remaining items on page 6.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 7, it is recommended that the commission adopt the proposed opinion and order in the joint petition of the First Energy companies for the approval of their default service programs.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion?
I have a motion, Madam Chair.
Commissioner Sweet.
Thank you. On behalf of the Vice Chairman and myself, I ask, that this joint motion be entered into the record as if I read it in its entirety. Before the Commission today for consideration of the exceptions to Administrative Law Judge Mary D. Long's recommended decision regarding the joint petition of Metropolitan Edison Company, Pennsylvania Electric Company, Pennsylvania Power Company, and West Penn Power Company, collectively First Energy, for the approval of their default service programs for the period June 1, 2019 through May 31, 2023. A joint petition for partial settlement was filed in this proceeding, the approval of which was recommended by the ALJ. However, multiple issues remain contested, including the way customers in First Energy's Customer Assistance Program, or CAP, participate in the competitive retail market and the appropriate scripting for First Energy's Customer Referral Program, or CRP. As outlined in this joint motion, we recommend that the issues of implementation of a CAP shopping program and the appropriate scripts for First Energy's CRP be referred to the Commission's Office of Competitive Market Oversight, or OCMO, for discussion with stakeholders and the submission of recommendations. Regarding the issue of CAP shopping, the ALJ recommended that First Energy be required to implement a CAP shopping program that prohibits CAP customers from entering into a contract with an electric generation supplier, or EGS, for a price that exceeds the utility's price to compare, or PTC. She recognized the evidentiary support showing that unrestricted cap shopping in FirstEnergy's service territory was harming both cap and non-cap residential ratepayers. We agree with the ALJ that there was clear evidence demonstrating that a significant number of FirstEnergy's cap customers paid significantly more than what they would have paid if they were default service customers. Higher rates make it more likely that cap customers will exceed their monthly maximum cap credits and incur charges they may not be able to pay. If cap customers are unable to pay their bills, this leads to increased uncollectibles, which are covered from the rest of the utility's residential ratepayers. As such, it is necessary to impose some restrictions on FirstEnergy's cap customer shopping in order to protect both cap customers and the non-cap residential rate base from increased and unnecessary costs. We agree with the ALJ's recommendation that FirstEnergy implement a cap shopping program excuse me, where cap customers may only enter into a contract with an EGS for a rate that is at or below the utility's PTC and does not contain an early termination fee. However, we find that the mechanics and details of this program are not fully developed to adequately ensure a program can be implemented in a successful fashion by June 1, 2019. Therefore, the ALJ's recommendation should be adopted insofar excuse me, as EGSs should not charge cap customers a rate greater than the PTC, nor charge them early termination fees. However, we propose referring the program to OCMO to work with stakeholders on the details of this new program and ensure a successful implementation. We request that OCMO provide recommendations to the Commission by the end of January 2019. Similarly, we propose the referral of the scripting of FirstEnergy's Commercial Referral Program, or CRP, to OCMO for its recommendations. The CRP is a voluntary program where a customer may be enrolled with an EGS at a rate that is 7% below the then effective PTC for a period of 12 months with no early termination fees. The OCA expressed concerns with the scripting and training materials currently in use, arguing that they do not provide sufficient education and disclaimers. The Retail Energy Supply Association, or RESA, recommended, among other things, that the parties convene a working group to investigate the causes of the decline in enrollments in the CRP and revise the scripting. We concur with RESA in that we should refer this issue to a working group, which will be led by OCMO, as OCMO has the resources and expertise to address this scripting issue, consider the consumer protection concerns of the OCA, as well as the competitive concerns expressed by RESA. We have concerns, however, with deferring OCMO's work product to 2023, as envisioned by the ALJ, and instead request that OCMO submit by the end of January 2019 its recommendations to this Commission for consideration. Therefore, we move that the exceptions of RESA are granted in part and consistent with this motion. The issue of FirstEnergy's cap shopping program be referred to OCMO for further review and analysis, with a recommendation provided to the Commission by the end of November 2019, the end of January, of 2019. Thirdly, the issue of scripts for the CRP program be referred to OCMO for further review and analysis, with a recommendation also provided to the Commission by the end of January 2019. And finally, the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you.
You have heard the joint motion of Commissioner Sweet and Vice Chairman Place. Is there a second to the motion?
Second.
Second by Commissioner Kennard. Discussion on the motion. Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, I do have comments to place on the record and ask that they be placed on the record in their entirety. And through my comments, I wish to state and highlight why I approve the plan in part and dissent in part from the plan. First, I wish to note my support for the shopping program, which prohibits CAP participants from enrolling with electric generation suppliers at a price which exceeds the current price to compare. The record here indicates that CAP enrollees' net expenditures above the PTC was more than $18.3 million from June of 2013 to March of 2018. I contend that implementation of a CAP shopping program is appropriate to protect the company's consumers from inflated, uncollectible expenses. Noting my support for the CAP shopping program and consistent with my position on previous default service filings, I must submit that this joint petition largely does not establish a default service plan that satisfies the procurement requirements under Act 129. This section provides that the default service provider must procure electric power via a prudent mix of spot market, short-term, and long-term contracts designed to ensure adequate and reliable service at the least cost to the consumers over time. When MedEd, Penelec, and PennPower's proposed default service programs include spot market products and short-term contracts, but no long-term contracts for any procurement class, I become concerned. West Penn's similarly proposes a default service program including spot market products and short-term contracts. However, in contrast to the other three electric distribution companies, West Penn's proposal grandfathers an existing long-term solar credit contract. This contract expires on May 31st of 2021 and therefore covers less than half of the proposed 5-year timeframe. It is my position that this lack of any long-term contracts covering the full timeframe of the plan does not fulfill the requirements of Section 2807E, which warrants my dissent on this issue. As I have continually submitted in each default service plan I have voted on, consistent with the Supreme Court ruling in Papowski versus Pennsylvania Public Utility Commission, a utility has the burden of proof of providing evidence justifying the omission of any type of contract enumerated in Section 2807E, whether it's spot, short-term, or long-term. In this joint petition, there is no evidence. In this case, there's no evidence to substantiate MedEd, Penelec, or PennPower's complete omission of long-term contracts and West Penn's utilization of a grandfathered long-term contract for less than half of the proposed timeframe. As such, I respectfully concur in part and dissent in part. Any further comments on the matter as amended?
Madam Chair, if I might
Commissioner Sweet.
briefly, while I intend to support the petition as modified, because I think in the overall scheme of things it is a step forward, I do want to associate myself with your remarks, as I have in the past. I continue to believe that that the prudent mix requirement does, in effect, require long-term contracts to be involved in these plans, and do agree with you, Madam Chair, that that should be the case. However, based on any number of previous votes on that particular issue, I think you and I are still in the minority on that particular issue. But I do agree with you on it, and we'll be voting in favor of the petition, notwithstanding that concern.
Thank you, Commissioner Sweet. Any further comments on the matter as amended? Hearing none. All those in favor say aye.
Aye.
Any opposed? As I stated, I will be voting concurring in part and dissenting in part, which should be
5-0.
4-1, actually. It's going to be 4-1. My dissent is heavy enough to be a no. So
Okay.
it just acknowledges the fact that I did approve and vote on the motion that was added to this matter. So the matter is approved 4-1.
Continuing on page 7, it is recommended that the commission adopt the proposed opinion and order in the complaint of the Bureau of Investigation and Enforcement versus Shays Trucking Enterprise.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 8 and matters presented by Director Diskin and the staff of the Bureau of Technical Utility Services, it is recommended that the Commission adopt in an omnibus motion all of the items on page 8, beginning with the tentative order regarding the licenses of electric generation suppliers, all of the items on page 9, all of the items on page 10, and including the 2 items on page 11, ending with the application of the Taurus Advisory Group.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 12, in matters presented by Chief Counsel Panque and the staff of the Law Bureau, it is recommended that the Commission adopt the proposed order regarding the petition of Blue Jay Wireless.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? I do have comments to place on the record. Section 214E4 of the federal law requires state commission or FCC approval for a carrier to relinquish an eligible telecommunications carrier ETC designation. The ETC designation is a status that this commission confers upon carriers that want to secure federal support to provide service in high-cost areas or want to provide lifeline service. The commission imposes additional obligations aimed at ensuring that consumers are not left without a service provider if a carrier stops being an ETC, and to ensure that the departing provider remits any required fees and assessments. This provider unilaterally ceased being an ETC provider of lifeline service without prior commission authorization until the staff conducted a follow-up. While I support a decision allowing this provider to no longer be an ETC provider of lifeline service, I also remind ETC recipients that they cannot cease providing ETC service without prior commission approval. Any further comments or discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 12, it is recommended in an omnibus motion that the Commission adopt the remaining 2 items on page 12, beginning with the petition of Warfield, Philadelphia, and including the 2 items appearing on page 13, ending with the tentative order canceling the certificates of public convenience for common carriers.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 14, and matters presented by Chief A.L.J. Rainey and the Office of Administrative Law Judge. It is recommended that the Commission adopt Judge Pell's initial decision in the complaint of Paula Ponte versus Verizon, Pennsylvania.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Yes, I have a statement on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into record as if I had read it in its entirety. Before us for disposition is the initial decision of Administrative Law Judge Christopher P. Pell that dismisses the formal complaint of Ms. Paula Ponte against Verizon, Pennsylvania. The complaint involves a Verizon PA pole and Ms. Ponte's allegations that lines situated on the pole inhibit safe building maintenance and that the location of the utility pole prevents the installation of a fire escape on the side of the building. Following the completion of the evidentiary hearing in this matter and upon review of the record, A.L.J. Pell established that the building in question was owned by a trust and that the complainant was the trustee. On the basis that the Commission regulations require a trust to be represented by an attorney in an adversarial proceeding, ALJ Pell reopened the record and ordered the complainant to obtain competent legal representation both for the trust and herself. ALJ Pell also warned that if Ms. Ponte failed to comply, the complaint would be subject to dismissal. Following the extension of an initial deadline, ALJ Pell dismissed the complaint because no attorney filed an appearance on behalf of the complainant and the trust. I do not advocate or support the premise that our regulations regarding the legal representation of business or corporate entities, including trusts, should be violated or ignored. Similarly, the directives that are issued by our presiding ALJs to participating parties during adversarial adjudication proceedings should be respected and obeyed. ALJs of the Commission already have a challenging and sensitive task in impartially managing the process in formal complaint cases. However, I believe that the simple exercise of judicial economy and administrative efficiency should have permitted Ms. Ponte to maintain her complaint action as a pro se complainant, and a ruling on her case should have been reached on the merits and the evidence presented. I note that the Pennsylvania Commonwealth Court may treat the issue of the legal representation of business trusts on a case-by-case basis and has inquired whether a business or corporate trust is valid. The available record indicates that no such relevant inquiries were made here. Ms. Ponte disclosed at the start of the evidentiary hearing that the building at issue was owned by a trust and that she was the trustee, and that she had purchased the building on behalf of the trust in February 2010. I also note that the Commission has exercised a certain degree of flexibility regarding issues of legal representation for business or corporate entities, including public utilities that operate under the Commission's jurisdiction. This flexibility was and is fully consistent with the concepts of judicial economy and administrative efficiency for participating parties and the resources of this Commission. The record in this proceeding discloses that the PECO Electric Utility performed certain work on the Verizon PA pole and placed its electric power lines at a greater distance from the building at issue. The record also indicates that Verizon PA performed certain work on its pole and straightened it, thus placing the attached Verizon PA wiring at a further distance from the building. Furthermore, Verizon PA's testimony indicated that its telephone wires on this pole presented no safety issues in terms of the voltage that they carry. Thus, it appears that the underlying adjudication had generated a sufficient evidentiary record for reaching a ruling on the merits of this case. Directing to the complainant to obtain legal representation for the trust and herself after the conclusion of the evidentiary hearing may be consistent with our regulations, but has also held the potential of further delaying the disposition of this case and increasing the administrative costs for all the participants and this Commission. For these reasons, I will be respectively concurring in result only in the disposition of this matter. Finally, though, I would also like to express my thanks to the personal staff members from other Commission's offices that provided useful input in this matter. Thank you.
Thank you, Vice Chairman Place. Any further comments or discussion? Hearing none. All those in favor say aye.
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 Any opposed?
And concurring in result only.
The motion passes 5-0, noting that Vice Chairman Place is concurring in result only.
Thank you.
Continuing on page 14, it is recommended that the Commission adopt in an omnibus motion the remaining two items on page 14, ending with ALJ Dunderdale's recommended decision in the rate filing of Columbia Gas.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman, that concludes the regular agenda items. Turning to the carry-in at the top of page 1, it is recommended by the Office of Special Assistance that the Commission adopt the proposed opinion and order in the formal complaints of Crescent Hotel Plymouth Meeting versus PECO Energy, UGI, and the Celeron Corporation.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
At the bottom of page 1 of the carry-in, it is recommended that the commission adopt the proposed order of the Law Bureau regarding the petition of the Pittsburgh Water and Sewer Authority.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman, that completes the carry-in agenda. We turn to the supplemental carry-in agenda. There's one item. It is recommended by Executive Director Freeman that the commission ratify the appointment of Catherine G. Sophie to the position of Director of the Office of Special Assistance.
Is there a motion to adopt the recommendation from the Office of the Executive Director for the appointment of Catherine G. Sophie to serve as the Director of the Office of Special Assistance?
So moved.
Is there a second?
Second.
So the motion by Vice Chairman Place, second by Commissioner Kennard. Under discussion, let me just say that you have already heard the motion. We will be voting on the appointment of Catherine G. Sophie as Director of the Office of Special Assistance. She has had a long and successful career here with the Commission, including most recently as one of the Deputy Chief Counsel in our Law Bureau, overseeing work regarding water, wastewater, and telecommunications, and the FCC. She has also served for 5 years as Deputy Director with the Office of Special Assistance, overseeing the legal group. She has been a reliable advisor to the commissioners, the executive officers, the bureau directors, the PUC staff on legal, regulatory, procedural, and policy matters. She possesses a bachelor's degree from Bloomsburg University and a Juris Doctor degree from Catholic University of America, Columbus School of Law. With our approval today, once we vote, we are pleased to have her move into yet another critical position here at the PUC. We know that there were a lot of candidates for this position. They were excellent candidates, especially the ones from within the commission. That bodes well for us as a commission, knowing that we have such excellent candidates. And with that, that is not to diminish any of them. But we are happy to vote on this recommendation for the appointment of Catherine Sophie as the Director of Office of Special Assistance. Any comments or further discussion on the recommendation for the appointment? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Congratulations.
Madam Chairman, that completes all agenda items for the commission's consideration today.
With no other business coming before us and without objection, the meeting is adjourned.